Welcome to Part 3 of Bright Ideas, a PTI Nebraska workshop on special education law. Part 3 begins some definitions of terms you'll hear frequently in the course of your child's stay in special education. Legislators like to be very specific, so even some definitions that would seem to be self-evident have been carefully crafted within the I.D.E.A. law or the federal and state regulations which implement it. When trying to resolve an issue, it's very important to know how the law defines a term that you and I might use daily and think we understand well, because it's the law's definition of the term, not ours, which will apply in any situation. Let's start right off with the term special education itself. The term special education means specially designed instruction at no cost to parents to meet the unique needs of a child with a disability, which we'll also have to define in just a moment. Special education might include instruction in a classroom setting, in the home, in a hospital or other institution, or in other settings according to the child's requirements. It also includes instruction in physical education, adapted, of course, to the child's requirements. The phrase, according to the child's requirements, is a key phrase throughout the special education process, as it has everything to do with the individuality of each child and the tailoring of services to meet those unique needs. A veritable smorgasbord of services related to special education will be available in most communities to address the needs of their children. Some of these related services are basic, like transportation to and from the location where services are to be performed. Other developmental, corrective, or assistive services are specific to a particular disability. Such related services might include speech-language pathology and audiology, interpretation, psychological services, physical or occupational therapy, recreation including therapeutic recreation, social work, school nurse services, counseling including rehabilitation, orientation and mobility, and even some medical services, although medical services are provided for diagnostic or evaluative purposes only. This is not an exhaustive list, just some examples of services which may be required to overcome any barriers a child's disability may present to a FAPE, that free, appropriate public education to which children with disabilities are entitled. Well then, I suppose the next definition we need to focus on is that of a child with a disability. Yes, that's defined in the law as well, although here the federal regulations have left room for individual states to choose how best to meet the intent of the law. There are two parts to this definition. To start with, we need to define the word child, and then move on to define disability. For the purposes of special education, in Nebraska we define a child as beginning at birth or the date of diagnosis of a disability through the end of the school year during which he or she turns 21. Now, what is a disability? Here too, the federal regulations leave some leeway up to the states. Nebraska's Rule 51 defines disability by listing 13 broad categories into which a disability will fall in order to be verified as a disability, which entitles a child to special education services. They are autism, deaf-blindness, hearing impairment, intellectual disability, multiple impairments, orthopedic impairment, other health impairment, speech-language impairment, traumatic brain injury, visual impairment, and behavioral disorders. Behavioral disorders is the term Nebraska uses in place of the term serious emotional disturbance, which appears within the federal regulations. Now, that's only 11 categories. The other two categories, developmental delays and specific learning disability, are complex enough that we'll have to define them in greater detail in a moment. Note that a medical diagnosis is not required in order for a child to receive services, as long as the child exhibits delays that can be attributed to one of the 13 verification categories. Similarly, just having a medical diagnosis of a disability which does fall into one of these categories does not automatically qualify a child to receive services. The child must also, because of the disability, require such services in order to receive a free, appropriate public education. In other words, if the diagnosed disability does not prevent the child from receiving a free, appropriate public education within the regular classroom curriculum, he or she won't need and thereby doesn't qualify for special education services. It's also important to note that the federal law leaves it up to each state to define the criteria for receiving special education services. Nebraska's criteria are published in a technical assistance document entitled Verification Guidelines for Children with Disabilities. A copy of this book is available online through PTI Nebraska's website, pti-nebraska.org. If you're relocating to another state outside of Nebraska, you'll want to check with that state's PTI, Parent Training and Information Center, to be sure that your child will continue to receive services under that state's regulations. PTI Nebraska can furnish the name and contact information for a PTI in any of the other states and U.S. territories upon request. Now let's talk about developmental delays. Developmental delays are defined as delays in physical, cognitive, communication, adaptive, or social or emotional development, which are observed and verified by appropriate diagnostic instruments and procedures. Of those 13 verification categories that Nebraska has identified, the category of developmental delays is treated in a unique way, both within the federal regulations and in Nebraska's Rule 51. Here's why. In general, developmental delays, when they're not caused by other impairments, are significant only during early childhood development. So, until the end of the school year in which he or she turns 4, a child in Nebraska with developmental delays is automatically entitled to receive early childhood special education and related services to address these kinds of delays. For children entering kindergarten, though, each individual school district is allowed to choose whether or not to include developmental delays in their definition of a disability. If the district chooses to include children with developmental delays, such a child may be eligible for continued services up to the end of the school year in which he or she turns 8. Beyond that age, if a child continues to exhibit developmental delays, the chances are that he or she qualifies for continued special education services based upon one of the other 12 verification categories. Hence, developmental delay ceases to be a category which qualifies as a disability for an older child. The other verification category that needs further explanation is that of specific learning disability. Learning disabilities in general do not qualify a child for identification as a child with a disability. However, a specific learning disability may. A specific learning disability is defined as a disorder in one or more of the basic psychological processes involved in understanding or using spoken or written language. Such a disorder may compromise the ability to listen, think, speak, read, write, spell, or do mathematical calculations. This includes such medical conditions as perceptual disabilities, brain injury, minimal brain dysfunction, dyslexia, and developmental aphasia. Explicitly excluded from the specific learning disability category are learning problems that are primarily the result of visual, hearing, or motor disabilities, of intellectual disability, of emotional disturbance, or of environmental, cultural, or economic disadvantage. Some of the other 12 verification categories tend to overlap the items on this list of explicit exclusions from learning disabilities. For example, a child with visual or hearing deficit will not be eligible for special education services on the basis of a learning disability resulting from the deficit. However, he or she may be eligible on the basis of the visual or hearing deficit itself. Parents who have been denied services on the basis of these exclusions are urged to contact PTI Nebraska for assistance. In any event, it is clear that a learning disability is disallowed if it's claimed to be merely the result of environmental, cultural, or economic disadvantage. We've defined disability and we've defined child. The law also has something to say about who is a parent. While it may seem obvious to some, the law never takes anything for granted. Throughout the child's receipt of special education services, this person is going to be the primary advocate for the child's welfare, negotiating with the local school district for the most beneficial and appropriate services it will provide under the law. First to be considered under the definition, of course, is the child's natural, adoptive, or foster parent. The law allows a guardian also to assume the role of parent. However, if the child is a ward of the state is specifically excluded from acting in the role of a parent for the purposes of guiding the child's special education. This is to prevent an obvious conflict of interest. Any other individual who acts in place of a natural or adoptive parent with whom the child lives or who is legally responsible for the child's welfare may be considered the parent. This could include a grandparent, a step-parent, or other relative of the child. Whenever the parents of a child are not known or cannot after reasonable efforts be located, or if the child is an unaccompanied homeless youth, the school system will appoint an individual to serve as the child's surrogate parent. In the event that the child is a ward of the state, a surrogate parent will be appointed by the judge in charge of the child's care. Again, a surrogate parent may not be anyone employed by the state or the local school district or any other agency involved in the education or care of the child to avoid conflicts of interest. As with the natural, adoptive, or foster parent, the surrogate parent is expected to advocate on behalf of the child while he or she is receiving special education services. The law also defines a special education teacher and sets out the minimum qualifications special education teachers must have. As parents, we really don't need to concern ourselves too much with these specifications. It's the responsibility of the local school district to see that the teachers they hire, in special education just as in any other discipline, are fully qualified. For our purposes, it's enough to know that special education teachers must be state certified in special education, in addition to any other certifications earned which may permit them to teach in regular classrooms. This concludes the third segment of Bright Ideas, an introduction to the special education process. In the next segment, we'll continue to define the terms used in special education.